All right. First of all, I want to explain that we're really here to celebrate the 20th anniversary of the entry into force of the Rome Treaty of the International Criminal Court, and indeed it is cause for celebration. Professor Gary informed us that she's unable to join us, and so we plan to go for 60 minutes instead of 90 minutes. We're holding this in meeting format, so if any of you have questions, please hold your questions until the speakers have finished. I understand you could also type questions into chat, but one of the reasons we wanted to do the meeting format is so that people could actually ask questions. If you do ask a question, try to keep it concise. Before we actually start, I want to send out thanks. We want to thank our co-host and co-sponsor, members of the staff of the California Lawyers Association section of International Law and Immigration. We want to thank the professors and staff at Loyola Law School, Southwestern Law School, University of Pacific McGregor School of Law, UCI School of Law, UCLA School of Law, and the USC Gould School of Law. If I forgot others, I apologize. We want to thank the professors and staff at the law schools, both for sending out the invitation, but also for the work they do to instill in new lawyers the skills to deal with international criminal justice pursuant to the just rule of law. We want to thank the members of the International Criminal Court Alliance, which promotes education about the ICC and hopes that education will lead to more nations joining the ICC. We want to thank our speakers, Professor Irina Zavaruka and Kristin Smith, who I will introduce in a moment. We want to thank all of you who are attending. I know that this is a holiday weekend. July 1st is the beginning of a holiday weekend in America. It's Canada Day. And so the fact that you were able to take the time and remember to be here, particularly in the meeting format where there's not reminders, we really do appreciate and we're grateful for all of you being here, even though it may be a holiday weekend. But July 1st, 2002 is the day that the Rome Treaty entered into force. And so we wanted to take advantage of that date to be able to have our celebration. There's another holiday for the ICC that's coming up soon. July 17th is celebrated every year as World Justice Day. And that's the day when the Rome Treaty Conference concluded with the vote to approve the treaty. So look on your calendars. I'm sure that there are going to be other events dealing with July 17th as a World Day for International Justice. I want to briefly describe 5 attributes of the ICC. There are many more than this, but these are the ones that frequently get discussed and I think are important. First of all, the ICC is a treaty-based organization independent of the United Nations, but with a working relationship with the United Nations. The ICC was formed to try individuals accused of genocide, war crimes, and crimes against humanity. The crime of aggression was added by amendment effective in 2018. The jurisdiction of the ICC is complementary to national courts, which means if national courts are able and genuinely willing to investigate and if warranted to prosecute, then a case cannot proceed before the ICC, and in the language of the Rome Treaty, it's inadmissible. Cases can be initiated by UN Security Council referral, by referrals from state parties, or by the prosecutor acting proprio motu. For a case initiated by the prosecutor acting proprio motu, the prosecutor must seek authorization from a pretrial chamber to proceed. Not true for the other referrals. The ICC has jurisdiction over individuals who are nationals of state parties or who commit crimes on the territory of state parties. There are a lot of other fascinating issues, such as the trust fund for victims, how the assembly of state parties works, the different chambers of the court, the rules of procedure and evidence, but I want our speakers to have some time to speak, so I'm not going to go through all of those. The 5 that I listed are ones that come up very frequently in discussions, though. 20 years ago, July 1st, 2002, the Rome Treaty entered into force, less than 4 years after the July 17th, 1998 conclusion of the treaty conference. The court commenced operations in March 2003. There's cause for celebration because in less than 20 years, a newly created court has become a centerpiece of the system of international criminal justice for widespread atrocity crimes. The ICC has its weaknesses. It does not have its own police force. It relies on nations to cooperate to obtain custody of those who are accused. Despite those weaknesses, the recent invasion of Ukraine shows how important the ICC has become. At the end of February 2022, the prosecutor announced commencement of investigation in proprio motu regarding alleged crimes committed in Ukraine and asked for nations to make a referral so there would not be the delay of seeking approval of a pretrial chamber. Within days, 43 nations made referrals. The ICC has become an important part of the international system of criminal justice. We celebrate the advancements of the ICC, but we must recall why we need the ICC. We need the ICC because genocide, war crimes, and crimes against humanity continue to be committed against large groups of people. Because of the large numbers, sometimes they seem like just numbers. But for each victim or survivor, the crimes committed are life-changing and may involve wives, daughters, sisters, husbands, sons, brothers, neighbors, and close friends. For each of those individuals, those crimes are a tragedy. Wouldn't it be nice if there was a criminal court that had no business? But that's not the world we live in. It's important not just for the victims and survivors, but for all of us to know that there is at least a possibility that those who commit unspeakable, heinous crimes will eventually be held accountable pursuant to the rule of law. We're grateful to our speakers for their willingness to be here with us today. Professor Irina Zavaruka is joining us from Ukraine. She's a graduate of the USC Gould School of Law, has been a law professor at many institutions, including most recently an adjunct professor at Southwestern Law School. We will take the example of Ukraine, the invasion of Ukraine, to discuss criminal justice and the role of the ICC. Kristin Smith is a graduate of the University of Notre Dame and Washington University in St. Louis, where she worked with the Whitney Harris World Law Institute. I'm going to take a little bit of a side here. Whitney Harris was a young naval officer who was one of the prosecutors at the Nuremberg trials. I met Mr. Harris when he came to Occidental College at the invitation of then professor, now mayor, Eric Garcetti, to discuss Mr. Harris's book, Tyranny on Trial, regarding his role in the Nuremberg trials, which was an event co-sponsored by the International Criminal Court Alliance. Back to Kristin. Ms. Smith worked as a criminal prosecutor, legislative analyst, worked on gender issues, including related to the ICC, and now directs the Atrocity Crime Initiative, a group of projects on atrocity prevention, response, and accountability jointly supported by the American Bar Association's Criminal Justice Section and Center for Human Rights. She's going to discuss potentials for U.S. engagement with the ICC. Before we do that, I'm going to show you a short video from the ICC, and then we're going to go directly to them, and I want you to have time to ask questions at the end of all that. So first, a short video. Make sure I can do this. Screen share. Here we go. Can you hear it? The point I hope you will take from that is that at the end of the program, that each of you will consider what you can do to support the cause of international criminal justice pursuant to the just rule of law. Professor Zawaruka.
Thank you. And thank you, Mr. Butler, for organizing this event and for this introduction. I would like to start also with a few general remarks on its significance. Ratification of the Rome Statute was indeed a historic event, and commemoration of the 20 years anniversary falls during indeed historic times. Russian aggression and the whole spectrum of international crimes committed in Ukraine makes this commemoration special and meaningful. Russian rhetoric on the war against Ukraine and Russian justification of this war takes us back to World War II. The privileges of the victorious power in World War II paved the way for the Russian Federation to accuse its opponents or ideologically inconvenient people and groups of people in Nazi crimes or collaboration with Nazis. During the time when Nazi concentration camps in Europe were closing and transforming into museums or memorials, Soviet camps kept growing in Siberia. Mass deportations and discriminations of national minorities, clergies, and intelligentsia were overwhelming and unfortunately remained unanswered. Nobody, absolutely nobody, took responsibility for mass crimes committed by the Soviet officials during World War II and onwards. Instead, and so ironically, Russia obtained the privilege of the superpower after the dissolution of the USSR and got its seat in the United Nations Security Council, the highest international body responsible for the maintenance of global peace and security. It's now easier for me to explain to my students what are the problems with victorious justice and why independence of the ICC is of such great value. The disappointment in the United Nations Security Council today is beyond comprehension. We all lament the helplessness of that body. At the same time, I think we should count and to appreciate even more the achievements of the Organization of the United Nations. The establishment of the ICC is one of the most important ones. Nobody probably will be surprised if from now on the Security Council will never be able to reach unanimity, especially on the matter of justice. In lieu of the discussion on the subject how to negotiate with Putin and let him to save face, I want to stress that accountability for the most atrocious crimes cannot be compromised. Such terms as diplomacy, politics, and criminal justice are not interchangeable. Criminal justice has its own path and accountability needs to be respected. The ICC is an independent judiciary and its design doesn't threaten sovereignty of the states, particularly because of the principle of complementarity. And thank you for bringing up the subject. We need to find new ways in popularization of the ICC among people around the globe. Civil societies, academia, professional associations, and international organizations need to unite the efforts in explaining the principles of the ICC to the people and their governments. The Ukrainian situation brings new perspective in this regard. Ukraine is a good example for the states which are reluctant to ratify Rome Statute. Ukraine didn't ratify the instrument, but it did recognize the jurisdiction of the ICC. Collaboration with the ICC is one of the priorities for the Ukrainian government and for the Prosecutor General of Ukraine. Ukraine actively demonstrates its willingness to investigate and to prosecute international crimes, but the scale of committed atrocities, the gravity of crimes, make it impossible solely to investigate and to prosecute. As of today, we have 20,699 registered criminal cases on crimes of aggression and war crimes. Russian war and the way how Russia conducts this war puts the system of international criminal justice to a test. There is obviously no judiciary in the world which would be able to investigate and to prosecute such magnitude of criminal activity. So the principle of complementarity is a priori necessary because of the lack of ability of the domestic system to investigate and to prosecute. That's how unique Ukrainian case in this regard. Just a couple of weeks ago, the International Law Association adopted the resolution and its conclusions and recommendations on positive complementarity. The conference happened just less than 2 weeks ago in Lisbon, Portugal. The document summarizes the principle of complementarity and the concept of positive complementarity. So I will allow to repeat myself that complementarity as an admissibility rule is implemented through the Article 17 to 20 and Article 53 of the Rome Statute. And positive complementarity is a policy of cooperation with national and regional criminal jurisdictions aimed at enhancing the capacity and willingness of those jurisdictions to investigate and to prosecute crimes within the ICC's subject matter jurisdiction. At this stage of Ukrainian situation in the ICC, it is hard to separate them, but we already can see certain pattern. Complementarity as an admissibility rule allows the Office of the Prosecutor to investigate and to prosecute the Ukrainian cases based on first subject matter jurisdiction, and most of the crimes are war crimes. And as the Prosecutor General of Ukraine, Irina Benediktova, said, we witness the whole spectrum of war crimes listed in Article 8 of the Rome Statute, unfortunately and tragically. Crimes against humanity, we witness deportation and forcible transfer of people, enforced disappearance of persons, imprisonment and other severe deprivation of physical liberty, torture, rape, persecution against certain groups or collectivity on political, national, ethnic, cultural, religious grounds. Genocide. As the war unfolds, we see much evidence that make us to believe that certain acts and crimes were committed with the intent to destroy the Ukrainians as a nation. Next, scale and gravities. For the jurisdiction of the ICC, the crimes have to be of a certain scale and gravity. We are all real-time witnesses to this aspect. And here just a few numbers. And I liked your point, Mr. Butler, when this numbers sound so great, it's easy to not to see human life behind those numbers. So the Office of the United Nations High Commissioner for Human Rights recorded 10,631 civilian casualties in the country. Almost 5,000 people are killed, almost 6,000 people are wounded, but actual figure could be significantly higher. Most likely it's higher. According to the World Health Organization, 500 attacks were committed on health centers since the beginning of the war. 334 attacks impacted facilities, 59 attacks impacted patients, 94 attacks impacted medical transport, and 164 attacks impacted medical personnel. Almost 1,000 children were killed or injured. Next principle important for the jurisdiction, the nationality and the principle of the territoriality. The crimes are committed by the citizens of the Russian Federation, with the exception of some mercenaries, but they are committed on the Ukrainian soil, from the Ukrainian airspace and the Ukrainian waters, the Black Sea and Azov Sea. And as Ukraine recognizes the jurisdiction of the ICC, the principle of territoriality is satisfied. And finally, the criteria of ability to investigate and to prosecute. Ukrainian law enforcement agencies are stretched to the level of impossible, and all investigators, prosecutors, forensic experts, and others work 24/7. The active hostilities make their work extremely difficult. Moreover, we all know by now that Russia doesn't respect the law of occupation, and every piece of land that comes under Russian control is impossible to access. We witnessed horrific bombardment in Mariupol, but the bottom line is that nobody knows the full extent of the crimes in the territories which are under Russian control. So the Ukrainian investigation teams work intensively, collective evidence as close to the front line as possible, because the front line can move anytime. I also want to mention the role of non-governmental NGOs in collecting evidence and gathering evidence. They do amazing work, but that's probably the subject of different conversation. So the magnitude of crimes and committed atrocities by Russian forces require international support. And here the concept of positive complementarity is in action. And one of the words that describes this war is the word unprecedented. It is unprecedented on so many levels, including international efforts and solidarity in investigation and prosecution of the international crimes committed in Ukraine. And I'm glad, Mr. Butler, that you brought this point. And just think about the chronology of the events. February 28, Prosecutor Khan announces his decision to seek authorization to open investigation into the situation of Ukraine. 4 days later, March 2nd, OTP received referrals of the situation from the 39 ICC state parties and opened an investigation into the situation in Ukraine. March 25th, 2022, a joint investigation team under the auspices of Eurojust was set up by Lithuania, Poland, and Ukraine, later joined by Estonia, Latvia, Slovakia. And then on April 25th, the Office of the Prosecutor, ICC, has become a participant in the joint investigation team on alleged core international crimes committed in Ukraine. Unprecedented. May 17, ICC deployed a team of 42 investigators, forensic experts, and support personnel to Ukraine, the largest in the organization's history. And now they are looking into the opening of a field office. Prosecutor Khan visited Ukraine twice already. And I'm not even talking here about the other forms of cooperation. For example, Atrocity Crimes Advisory Group for Ukraine and bilateral agreements between Ukraine and other countries. I also purposefully omit the question of the prosecution for the crimes of aggression, because it doesn't fall under the jurisdiction of the ICC, but that is another great example of great international collaboration. And now let me bring up a few obstacles for the domestic judiciary, or so-called accountability gaps, which can be fulfilled by complementary jurisdiction of the ICC. First of all, the most important question is a question of immunity. Rome Statute does not recognize the immunity of head of state. For example, only ICC has authority and competence in that regard. The Criminal Code of Ukraine has a norm on criminal offenses against peace, security of mankind, and international legal order. And not many criminal codes feature this norm, which basically is the norm on the crime of aggression. Article 437 is called planning, preparation, and waging of an aggressive war. But here again, the problem, how to bring to justice the perpetrators who enjoy immunity. Next, Ukrainian Criminal Code in Article 438 regulates violations of rules of warfare. And of course, as it is important to have this article, we can see that it's not perfect. There are a few problems with this norm. First, the list of criminal acts is rather limited compared to the Rome Statute. And secondly, the law here refers to the violations of the rules of warfare recognized by international instruments consented by the Parliament of Ukraine, by the Verkhovna Rada of Ukraine. It would be much better if it referred to the Rome Statute or customary humanitarian law. Among international crimes, the Ukrainian Criminal Code has provision on a crime of genocide, but it is silent on crimes against humanity. This fact obviously could be a factor in favor of the jurisdiction of the ICC. Another gap in national criminal law is silence on command and superior responsibility. I want to be clear that the Ukrainian government and the prosecutor general and Ukrainian people are aware that majority of crimes will be investigated and prosecuted in Ukraine. And I want to inform you that a draft of law on amendments to the Criminal Code of Ukraine is ready. It's not signed yet into law, but civil society keeps the pressure on. So it will extend the possibilities to bring to justice those who are guilty of international crimes in domestic judiciary. And in conclusion, we are witnessing unprecedented global collaboration in criminal justice. And this is probably the best time to promote the ratification of the Rome Statute. People of the 21st century understand what the principle of accountability means, but we probably need to do some more work on explaining what the principle of complementarity means. ICC is not a threat to the sovereignty of the states, and it has complementary jurisdiction. And as you, Mr. Butler, mentioned, only the states have the primary right to investigate and prosecute the crimes within the ICC's jurisdiction. The ICC has jurisdiction over case only if no state is genuinely investigating or prosecuting a case of that kind. So people and governments will eventually understand that the dilemma on joining the ICC comes down to the question, which jurisdiction would be the best for investigating and prosecuting the most atrocious crimes under certain circumstances. And with this, I will be looking forward to your questions and to the discussion and to the presentation of Kristin.
Well, thank you very much. That was a very enlightening. Kristin, to you. And I think maybe a good segue for you too.
Yeah, thank you. And thanks again. Thanks again to the organizers for putting this on, especially today. It's really a joy to be able to talk to you about the importance of the International Criminal Court. And thank you to my co-presenters too, who already gave very compelling presentations of why it's so important, and including how those issues have played out in Ukraine specifically. I work for the American Bar Association. I'm not speaking today on behalf of the American Bar Association. I'm just doing so in my personal capacity. But since we might have some other lawyers on the line, if you're interested in their policies supporting the ICC, the ABA does have a long history of supporting international criminal justice, the ICC, and also the US relationship with the ICC. You can check those out on the ABA President's page, or we have them compiled on our ICC project page as well, which is aba-icc.org. So I'll leave that there, but I offered to talk about jurisdiction, complementarity, which I think we've already heard a lot about, so I'll keep that short, but then specifically about the US history and engagement with the International Criminal Court, some of the positives, some of the challenges. So I'll start with jurisdiction. Sean gave a great summary of the court's jurisdiction. I just thought I'd illustrate a few examples. The court has 123 states parties at this point. It doesn't include a lot of particular world powers like the United States or Russia or China, and so that has limited its ability to address situations across the world in some respect. But it does have jurisdiction in a few situations on the territory of state party when crimes are committed by nationals of states parties, by UN Security Council referral, which examples of those would be Sudan and Libya. And unfortunately, I think we've seen recently the political block to future UN Security Council referrals when countries like Russia and China have said publicly that they're not going to do that anymore. So that's another kind of practical obstacle to the ICC gaining jurisdiction in some situations, like Syria is a good example where that's been blocked many times. And then also, by special agreement, which Ukraine is an example of, since Ukraine submitted those declarations accepting the jurisdiction of the court. And at this point, there are 17 open investigations at the ICC, which is certainly more than ever before and includes more regions in the world than ever before. I think probably our viewers will be aware the first few ICC cases were in Africa exclusively. And so now it's investigating crimes more globally, which I think is a good thing. And then we've heard a great presentations on complementarity and how that plays out. I just wanted to add a few kind of technical aspects that challenges, even though complementarity is kind of part of the admissibility process to a case, it doesn't mean that a state or an individual can't challenge that decision later in the process. So there's kind of an initial assessment by the prosecutor about whether a case or investigation fits within the jurisdiction of the court. Sometimes the pretrial chamber, as noted, has to make a decision on that in certain circumstances too. But a particular person could always challenge admissibility later in the process once an arrest warrant is issued, and a state could as well, as several states have in the past. They've asked the court to defer investigations, saying that they're already doing them themselves. Afghanistan did that, and now it's a bit paused, but I would expect that with the change in political leadership there, that would be not probably an effective argument anymore. Philippines has done that recently as well. And so we just saw the prosecutor recently ask the pretrial chamber if he can move ahead with an investigation, arguing that although the Philippines provided some evidence, they haven't provided evidence that their investigation covers the same things, the same crimes, the same conduct as the court's investigation would. So there's kind of a same case, same conduct test that the court typically looks at, and whether ongoing investigations mirror those at the court. So, that sometimes that means that that it might just depend where a person is being prosecuted, because as we've discussed, the ICC also typically goes for those most responsible for crimes rather than those who might be directly implementing them, although, sometimes a person can be both. But sometimes national jurisdictions will offer examples of prosecutions, but it turns out that they've prosecuted direct perpetrators rather than those who have planned the crimes, which can be a benefit of the ICC, that it has the ability, and maybe a national jurisdiction would have trouble prosecuting that person because it might be seen as more political locally or something. So there's lots of kind of benefits to having the ability of the ICC to prosecute some people in a situation, at least, although as we've also discussed, it's pretty limited in its capacity because it can only take so many cases as well. So then I offered to add a little bit of history about the US relationship particularly. So as I'm sure you all know, the United States is not a state party to the International Criminal Court and the Rome Statute, but it did play a crucial role in negotiating the Rome Statute and its elements of crimes and the rules of procedure and evidence, which are really important to, ensuring the court has fair trials and is effective and efficient. So although the US, I think, signed but didn't ultimately ratify the statute, it's not a party right now. And so it's had kind of an up and down relationship with the court, depending on how the administration views it and its effectiveness and creates policies. So sometimes the United States has supported the court on a case-by-case basis and offered information. In two specific examples, the US has helped to transfer suspects that ended up surrendering to forces and then were transferred to United States control or surrendered directly to US forces abroad. And so that was really important because that, provided the court with two suspects that it needed to move forward with trials. They've also participated as an observer at the ICC Assembly of States Parties sometimes in the past. But then on the negative side, different administrations have also made rules about how other states can engage with the court and have tried to discourage states from engaging, particularly during the Bush administration, although that lessened as further in the administration when they realized that some of that was hurting bilateral relationships between the United States and other countries. And then in the most extreme negative example, the United States actually imposed sanctions on the ICC prosecutor and a senior member of the Office of the Prosecutor's staff during the Trump administration. So those were removed, but it certainly marked a low point in the relationship. And then there's actually legal restrictions. Because the United States isn't a state party, there are certain legal restrictions on the way that it can engage with the International Criminal Court and support it, even when it wants to do so on a case-by-case basis. So I just thought I'd outline a few of those. There's two major ones. The first has to do with funding, and the second one has a lot of restrictions that has to do with pretty much almost any way that the US could cooperate. So on funding, the Foreign Relations Authorization Act from 2000 and 2001 has a provision that is treated as permanent that says none of the funds authorized to be appropriated by this or any other act may be obligated for use by or for support of the International Criminal Court unless the United States becomes a party, which it obviously hasn't done. So that really restricts any financial support that the US could provide to the court. There's been a provision included in the past few appropriations acts that includes a proviso that funds may be made available for technical assistance, training, assistance for victims, protection of witnesses, and law enforcement support related to international investigations, apprehensions, prosecutions, et cetera, of atrocity crimes, as long as they don't include US persons or those of major allies. So that's a potential way that the US could engage is using funds to support assistance in those particular areas. At least experts have argued so far. So that's a potential, but that's only effective as long as it's included in appropriations legislation. So hopefully it will be in future years as well. And then the other major restriction remains the American Service Members Protection Act of 2002, which is codified at 22 USC sections 7421 to 7433. The title and congressional findings suggest that its purpose is really to protect American service members and nationals from risk of ICC prosecution. It was adopted as part of appropriations legislation, but is treated as having permanent effect. And some portions, like the military assistance piece I mentioned earlier, have since been repealed. So some of its restrictions have been removed over time, but a lot of them still remain. And it was adopted with pretty big bipartisan support back in 2002. And it generally prohibits US courts, state and local governments from responding to requests for cooperation, prevents extraditing any person to the ICC. It limits mutual legal assistance obligations that could be interpreted as requiring the US to cooperate with the ICC. It prohibits any investigative activity relating to preliminary inquiries, investigations, or prosecutions on US territory, which has had a practical impact. For example, if there's a witness or a victim who's trying to communicate with the ICC and they happen to be in US territory, it prevents the court from doing that. So I think, according to some reports that the American Society of International Law and others have done, that's been a practical restriction that has actually played out and limited, some investigative activities, even that don't involve, the US or allies, purely conduct of foreign nationals. The American Service Members Protection Act also prevents the transfer of certain information to the ICC. And then there's a kind of large general prohibition on support to the ICC, which is defined as assistance of any kind, including financial support, transfer of property, services, intelligence sharing, law enforcement cooperation, training, and some other areas. So the one positive is that there's a big qualification in the American Service Members Protection Act that's kind of referred to as the Dodd Amendment, which says that nothing in that subchapter, so none of those restrictions listed, shall prohibit the United States from rendering assistance to international efforts to bring to justice. There's a list of names, and then or other foreign nationals accused of genocide, war crimes, or crimes against humanity. So that's a really important carve out that the United States has used in the past to be able to support certain activities regarding investigations that they feel comport with U.S. interests. And so they've been able to provide certain information, offer, I think, some witness protection services in the past, and some other maybe practical ways of cooperating in kind, not financially, but it does still, there's kind of always a question of whether, when it wants to engage, how much it can do and how much it's limited by those restrictions. So those continue to exist. And then I know we're running short on time, but I just wanted to kind of offer some preliminary things on the benefits of the Rome Statute, including for even countries like the United States. The ICC obviously is a way to implement values. The US has always argued it's a big supporter of international justice and accountability. And I think, as we heard about Ukraine, the ICC is really a key player in that, regardless of whether cases actually are at the ICC or national jurisdictions. And then another key one I wanted to mention for a US audience is that even though it's not required in the Rome Statute, the ICC has encouraged, being a member of the ICC has encouraged states to shore up their national laws on atrocity crimes, like we were talking about with Ukraine as well. And the United States has some significant gaps in its own domestic law on accountability. There's a bill out right now about war crimes that would add present in jurisdiction and also eliminate the statute of limitations for war crimes, which is a good thing in terms of international law, because we all know these cases take a long time to prosecute in some situations. And there's also no crimes against humanity statute at all. So the US has statutes on genocide, child soldiers, and torture, but not crimes against humanity. So if anyone is found in the United States and has committed war crimes abroad, not against a US citizen, but that would we'd lack jurisdiction to prosecute that person, and we can't prosecute them for having committed crimes against humanity as well. So the Rome Statute can encourage countries to do that kind of thing as well. And I'll leave it there for now. Thank you.
Well, thank you very much. I actually want to direct a couple of questions before I let everyone else have theirs. And they're specifically about the US and investigations for Ukraine. Kristin, I actually think I heard this at a program you hosted, that a former ambassador at large for war crimes issues, was it Clint Richardson, who is heading an investigative team in Ukraine? Can you talk to us a little bit about that? Williamson. Can you talk to us a little bit about that?
Yeah, I mean, I don't have details, obviously, of their work, but the US has stated as a matter of policy that it's supporting investigations of atrocities in Ukraine. It's working closely based on their statements with the Prosecutor General's office in Ukraine, so supporting national capacity to do prosecutions, but they've also said that they're engaging with actors at all levels, including the International Criminal Court, which is really positive. And an example of case-by-case support, obviously this is a case where the US has decided it wants to support the ICC's work, but still an example of its value. And hopefully the more of that happens, the more the United States can see the value of the court, trust in its procedures, and see its effectiveness. So they are supporting investigative teams and experts that are working, and also I think trying to create ways to share information with the court or respond to any requests that might come in. And they're also preserving evidence. There's a conflict observatory the State Department has established, and there's an advisory group as well, Atrocity Prevention Advisory Group, I think it's called. So, hopefully those other mechanisms that the US are supporting can feed into accountability efforts at the ICC as well as in other venues that they might be able to happen.
Well, you anticipated my second question. My second question was about the State Department having made what they're doing, and you already did that. So I don't have to ask that again. So thank you very much. I'm going to turn it over to the crowd. And so if anybody has questions, please raise your hands. Let's go one at a time, and I'll recognize it. Okay, Mr. Carrasco.
Hi, Gil Carrasco, professor of law at Willamette University College of Law. I enjoyed both your presentations very much, well, including yours, Mr. Butler. But I was, always disappointed in the United States exempting itself from the norms of international law with this doctrine of non-self-executing treaties that the United States uses as an excuse not to comport with international law absent some implementing legislation by Congress, such as the Refugee Act of 1980, for example. I was wondering about Ukraine. It's interesting that Ukraine has not adopted the Rome Statute, and although it subjected itself to the jurisdiction of the ICC, I'm curious why that is, and whether it's the same sort of lawlessness that the United States is characterized by, or whether there's some better reason in Ukraine for it not adopting the Rome Statute.
I guess I will take this question. Ukraine signed the treaty but didn't ratify it. But when in 2013, when the Revolution of Dignity happened, and then there were mass violations, grave violations of human rights, and after we had the election of a new president, the Ukrainian government launched the declaration to the ICC to investigate certain cases. And then the annexation of Crimea happened, and occupation of Donbass, and that was also triggered the necessity to appeal to the International Criminal Court. So this is a reason, this is another way how the country can recognize the jurisdiction of the ICC by launching declaration and recognizing the jurisdiction. But the jurisdiction over those cases would start from the time of launching of the declaration, so and onwards. So that's the way how the state can recognize the jurisdiction of the International Criminal Court. It's not ideal. And we have many questions to the government of Ukraine, of course, because we believe that it should have been ratified. But it's just an example, as I said, when the society and the government recognizes the value of the international criminal justice in real extreme circumstances. So another benefit, and I'm sorry, I'm just shifting to another question, another benefit of having the whole international community supporting ICC is the fact that even though, as Mr. Butler said, International Criminal Court doesn't have its own police, and the decisions of the court are secured by the party states, the states parties to the Rome Treaty. And it's very important because that's how it executes its power. So, for example, if Mr. Putin will be traveling to the state party to the Rome Statute, that state has obligation to hand him to justice, of course, if the process will be, if the case will be open and it will be legitimate. So that's another big benefit, to have as many states parties as possible to execute the decisions of the court.
I'm going to just add a brief comment. When the Rome Treaty Conference happened, one of the things that the U.S. wanted was to have all cases initiated through the UN Security Council. And I think now with 2020 hindsight, we can see why that was not a good idea, because there's only been two, and in the current situation, it doesn't look very likely that there will be many more UN Security Council referrals. So if that was the only way that the ICC was going to get cases, it would be out of business, not because of the conflicts, but because no cases got referred. So it's too bad that the U.S. took that position and voted against the treaty at the Rome Treaty Conference. It did thereafter sign and has shown different types of support, but it's really good that it's not limited to a UN Security Council referral. Kristin, anything you wanted to add?
Just briefly, this is slightly tangential, but the non-self-executing issue is one of my bugaboos too. In international law, it's very frustrating. But you know what? One thing about atrocity crimes is they're also, use Kogan's violations and violations of customary international law. So we have the Genocide Convention, we have the Geneva Conventions, which have obligations to prevent, extradite, or prosecute, punish those violations. So the Rome Statute, and states adopting their own frameworks for cooperating with the ICC or cooperating with other states make those obligations effective. And so the Rome Statute can encourage states to do that and kind of give examples of how those agreements work. And then another, just thing in international law is there's no crimes against humanity treaty. So even though that, is considered a customary international law violation, and that issue has been recognized by US courts that crimes against humanity is included in those violations, there's no specific treaty on that makes clear those obligations or could push states to adopt them. So that's just another kind of impunity gap in international law around this subject.
Professor Lutz, you have a question?
Yes, thank you. And thank you for the wonderful presentations of both, all three of you, actually. The ICC has often been chastised, so to speak, internationally for its concentration on Africa and the various issues that arise in terms of atrocities and so on in that continent. But of course, we know that there are those types of crimes in other parts of the world frequently, and they haven't been subject to much attention or direct attention of the ICC. How do we move beyond the limitations that are imposed by the structure of the ICC to begin to treat countries in other parts of the world equally with respect to the crimes that have been and are being committed.
Anybody want that one?
Yeah, that's a great question. I'll start if that's okay. You're completely correct. That's what I mentioned in my kind of beginning of my remarks, that the first few investigations were focused on Africa, and that is a valid and understandable perception. The courts has grown in its investigations. Like I said, now there's 17. It just issued arrest warrants for 3 people in the Russia-Georgia situation. So that's an example of, particular suspects now outside of Africa, in addition to just investigations. But, the background to that is that a lot of African states were state parties to the Rome Statute and signed up and, decided to submit themselves to that jurisdiction. And that's not necessarily the case in other parts of the world. So I think, Asian countries don't have as many proportionate ratifications. And so there's, as we talked about, there's just limits on where the court can engage, because it is based on the statute's jurisdiction, which is based on state sovereignty and signing up, other than the UN Security Council referral option. So, that's just a practical limit, but it does mean that justice can be pursued in some countries and not others. One good thing, I think, in terms of supporting the Rome Statute and the court and its growth, is that it brings attention to the need and the expectation for international justice. So even if it doesn't end up at the ICC, I think it has encouraged, victims that want justice for their situations to advocate and seek it somewhere. And so there might be, opportunities to establish a national tribunal. There have been kind of special units set up in certain countries. Uganda has one. The Central African Republic has a special criminal court that they've set up to deal with atrocity crimes and other crimes, even though the ICC also has investigations in those situations. And there are other examples too of domestic courts that have set up kind of this special focus on investigating atrocities. And then, there's also the opportunity for hybrid tribunals, either set up through the UN or some other kind of mechanism that can contain, international and national elements, or even pursuing justice at regional courts, like the Inter-American Court or the European Court of Human Rights, for kind of related acts under those documents. So I think, the Rome Statute does give kind of a reference and motivation point for seeking justice, even if it ends up in a different venue. And all of those things can be supported. Sometimes local justice is better and can be, more seen by victims or more incorporated into the national jurisdiction and kind of build capacity. So there's definite benefits to doing it locally as well, where that's possible.
And I'm just going to quickly add 2 points. A lot of the African cases were self-referrals, which Kristin referred to, but also the court has been moving on. So the Philippines, Afghanistan, Iraq, and Iraq complementarity, they said Britain had done a proper investigation. Colombia, based on complementarity, they've postponed doing anything on the assurances of the Colombian government that they're proceeding. Venezuela. And so, yes, it started out more with Africa, but that was because mostly of self-referrals, and the court is moving on to other regions.
And we probably will end with what we started with, promotion of the ratification of the Rome Treaty, right? Then more states ratify, then more we have self-referrals, other states referral. And again, Ukraine is a good example on that.
To just as a quick follow-up, to what extent do you perceive that there's an international push to obtain greater number of states parties to the convention? I mean, you mentioned the local type of tribunals and so on, and those seem to be more or less almost a defensive mechanism in some cases to avoid the international aspect of the ICC and keep it local to the particular state. So yeah. I'm just saying, where are the political forces that are operating that promote adherence to the Rome Convention?
Well, the court itself is very active on that. Just that I was listening this morning to, they had a ICC at 20 conference, and the universality was a big part of that. So the president of the Assembly of States Parties speaks about its value often. They engage with other states, including non-state parties, hoping to build trust in the institution and to build that relationship. So that's certainly a part of what the court sees as its work. There are other organizations promoting that as well that work, on that issue specifically more directly. There's the Coalition for the International Criminal Court, which is the kind of biggest coalition of civil society that I think, helps to facilitate that work. I'm familiar with Parliamentarians for Global Action. They've done a lot of work on universality and working with their members in specific countries to promote an understanding of the International Criminal Court and promote ratification where that seems possible as well. So there definitely are groups and the court itself working to increase the statute.
And I think that there is also another trend in this positive complementarity concept, when it's not about the ICC to get a case to investigate and to prosecute it. It's also about policy to help to create to help to build capacity and ability of national jurisdictions to prosecute and investigate themselves. It's not the fight for the case. It just is a matter of justice, in which jurisdiction the justice can be performed in the best way. And for example, again, I'm speaking for the case in Ukraine, but there are many other countries. The work with victims, for example, it's in Ukraine such an overwhelming amount of tragedies and victims. And investigators are so busy with, gathering evidence, and they, there is a strong need to have help to work with victims. And the NGOs are engaged into that, but also foreign partners. So the work with witnesses, the analysis of their, crimes, involvement experts, for example, military experts now when we are talking about the war crimes, and all these resources like building capacity and helping national jurisdictions to do better justice is very important too. I think it can be a very attractive part as well.
We've gone over our hour, but I'm willing to stay longer if other people are. Samira, I see that you have a question. You're on mute.
Yeah, you can hear me now? Okay, perfect. Thank you. My name is Samira Gachel. I'm an independent documentary filmmaker investigating global political issues, and my background is Iranian. So I'm going to have a specific question regarding the countries with instability, political instabilities. Has there been any cases when a regime or a government, for that matter, has joined the treaty, has ratified the treaty, but then the regime changes and then, or the government changes, and then they say, we no longer acknowledge that, we want to be removed. Has there been any cases like that? And what is the position of the court on that, if that actually arises?
Kristin, I can see you nodding your head.
Yes, there have been a few cases with that exact situation where a country has signed and ratified the Rome Statute and later pulls out of the treaty. And there is a formal procedure for that. So they need to notify the court in the UN, just like you do when you sign a treaty. And then that removal becomes effective a year later. So the Philippines is an example. The Philippines was an ICC state party and now is not. But the court started its examination of crimes there when the Philippines was a state party. So they've held, at least at this stage, that they can continue with the investigation. But then the investigation will just be limited to crimes that committed while the Philippines is a state party. So it couldn't investigate crimes happening in 2022, for example, but it'll keep its investigation to the time when they were a state party. There have been a few others as well. I think Burundi is an example of that. Sean's nodding. Okay,
Yes.
so yeah, so there are some limitations then that come into play, but the court can still have jurisdiction over the time when the state was a party to the statute.
And there's also been withdrawals of signatures. Signing has a significance under the Vienna Convention on the Law of Treaties. The US signed and then withdrew its signature. Russia signed and then withdrew its signature. So yeah, there's a way sometimes people pull away from what they had earlier said they were going to agree to. Anybody else, other questions? All right, we've gone past our time. And so everybody, I want to thank our speakers. Thank you so much for joining us today. I want to thank all of you who've joined. Oh, Mr. Carrasco, do you have another question?
Hey, Sean. Hey, Sean.
Well, yeah.
Sorry, Melissa Elaine has a question in the chat function. Her question is, has ICC investigated alleged crimes in the environmental context? For example, decimation by one nation state of another state of forests or other natural resources. Do you see a potential for nations failing to honor their pledge to oh, it's hard for me to read.
Kristin answered that, and she just types faster than I do. She got in the answer. Ecocide. There is a movement to add a new crime to the jurisdiction of the court, ecocide. And for us in Los Angeles, we're lucky. One of the proponents of that is a professor at UCLA Law School, Kate McIntosh. And so that is a move. Whether it'll happen or not is a different question, but it is something that's under consideration.
Well, thank you. Thanks, everyone. This was very informative.
All
I
right,
just
well,
want to add that Ukrainian Criminal Code has an article on ecocide, by the way, it is there. But I want to remind here that it's an individual liability, right? It's a criminal law. So when we are talking about environment, we're not talking about the responsibility of the state, but in responsibility of the individuals. And if it's about ICC, those will be the high level positions and government officials.
the thing I want to close with is that I hope each of you will believe that there is a value to promoting accountability pursuant to the rule of law for international crimes. And it's not an easy thing. So there's going to be a problem. If Putin is accused of something, how are people going to get custody of him? There's issues, and that happened with Sudan for a long time. And so, again, not perfect. There are some people who have died who were accused and never got brought to justice. So it's not a perfect solution, but it is something that what we hope is you will find worthwhile putting some of your time and effort into. So thank you all for being here.
Thank you.
Yeah, thank you so much, everyone.